Hello students, welcome to our polity class series. In this class, we will discuss about the important amendment of Indian Constitution. First, what is the meaning of amendment? As we all know, our constitution was formed in 26th of November 1949 and it was imposed in 26th of January 1950. Clear? So our constitution was basically formed in 26th of November 1949 and now 26th of January 1950 it was imposed in India. It was enforced in India. So till now it is around 50 or 74 years. The constitution was formed before 74 years. So that time or today's time, there is a lot of difference between the time and the scenario of all the things. So if we want to change anything in our constitution, change means if we want to delete anything, if we want to remove anything, then it is required to do amendment in Indian constitution. So amendment means changes in Indian constitution. And what does change stand for? If we want to add something in Indian constitution, that we need to amend the constitution. And if we want to subtract the Indian constitution, so anything from Indian constitution, then we will also have to do amendment in Indian constitution. So the changes in Indian constitution are known as amendment of the Indian constitution. Clear? Till now, there are total 106 Indian constitutional amendment has been done. Means there are total 106 time changes has been done in our Indian constitution. So we have to discuss the important amendments of Indian constitution. We do not have to discuss all the 106 amendments. We only have to discuss the important major amendments of our constitution. Clear? Okay. So let's start. Okay, who can do amendment? Who have power to do amend of Indian constitution? First, Article 368 of Indian Constitution provide the amendment procedure of Indian Constitution. So under which article can amendment will be done by in our constitution? Under Article 368. Article 368 says that only Parliament has power. Parliament can do constitutional amendment only. So under Article 368, state do not have any power or state legislature don't have any power. State legislature cannot amend our Indian constitution. Only Parliament has power. Parliament can amend Indian constitution. In Parliament, the bill has to pass or start by either of the house. There is no criteria. Either Lok Sabha or Rajya Sabha can start the constitutional amendment bill. So first, bill can be started by either of the house. Let's suppose bill is started by Lok Sabha. The people are agree to amend the constitution. Then at least 2/3 members of total seat has to sign over it. Then if the bill moves to the another house, means Rajya Sabha. Then 2/3 or special majority is required to pass the bill. Then bill will be sent to the president, and president has to provide his assents also. And after the sign of president, the amendment will become known as the Amendment Act. And only this type, through this, we can amend our Indian constitution. Clear? Okay. So now let's start with our first Amendment Act, which was done in 1951. We have to understand when was the amendment done and what is the criterion, what was changes in our constitution. Okay. The first Indian Constitutional Amendment Act, which was done in 1951. So after the imposition of Indian Constitution, after 1 year, the first amendment was done. In this amendment, basically, the 9th schedule of Indian Constitution was added. So 9th schedule's topic is Land Reform Act. Basically, simply you have to understand what is 9th schedule. 9th schedule was made to basically challenge the right to property, fundamental right. Before 1978, there was a fundamental right known as right to property. It was a major challenge for a government to capture the property of the people for any project. If a government, let's suppose, wants to make a highway or road lines, then it is required to take the people's property. As before it was the fundamental rights, people can directly move to the Supreme Court and High Court and they challenge center and state government in the Supreme Court on the behalf of fundamental right abolition Article 31. As that time fundamental right was the and the right to property was the fundamental right. Now in First Amendment 1951, government made a schedule known as ninth schedule. If any act was made and it was basically put into ninth schedule, then no one can challenge this act into Supreme Court and High Court before 1973. The ninth schedule of Indian Constitution was, this was a type of, we can say, a schedule. If any act was formed by any state government and central government, if a state government and central government put this act into ninth schedule, then it cannot be challenged in Supreme Court and Act Court. Mean all the act which were the part of ninth schedule or which are put into the ninth schedule will not be enforceable or challengeable in any court. So there are some amendment also related to the ninth schedule. The Fourth Amendment Act 1955 includes some more act in ninth schedule. The ninth schedule was added in First Amendment Act 1951, but there were some changes done in ninth schedule under some other amendment. The Fourth Amendment Act, when was Fourth Amendment Act passed? Fourth Amendment Act was passed in 1955. Included some more acts in the ninth schedule. So it includes some more act in ninth schedule. The Seventh Amendment Act was passed in 1964, included 44 more act in ninth schedule. The 29th Amendment Act was passed in 1971 and include 2 Kerala Act on land reform in ninth schedule. And 34th Amendment Act in 1974 included 20 more land tenure and Land Reform Act, various state in ninth schedule. Why these acts are basically added or included in ninth schedule? As I told you, any act which is included or added in ninth schedule will not be challenged by any person. So that's why most of the government use this schedule for their benefit. They made the law. They basically include this law as a ninth schedule, and no person, if the rule is also against fundamental right, then no one can challenge the rule as it was the part of ninth schedule. Laterly, after Keshwananda Bharati decision in 1973, Supreme Court declared that if a rule is for not public welfare, then it can be challenges in Supreme Court. So as of now also, if there is a rule which was added in ninth schedule, if there is any act or there is any law which was formed by any state or center government as a part of ninth schedule, can be challenged in Supreme Court and High Court if it is not for public welfare. But before 1973, it was not the part of basically this type. So the decision was done in 1973 under Keshwananda Bharati case. So I hope you understand First Amendment Act. First Amendment Act was passed in 1951. Amendments means changes in the constitution. Mean if we want to add anything or if we want to subtract anything in constitution, then we need to amend the Indian constitution. Only Parliament has power. Parliament can amend Indian constitution under Article 360 Act by passing the bill from both the houses at special majority, and after the consent of president, then changes can be done in constitution. First Amendment Act is related to the added of ninth schedule. Clear? Okay, 3 more grounds on restrictions of Article 91, freedom of speech and expression, were also added under ninth schedule of Indian Constitution. Public order was also added. Friendly relation with foreigner state also added, and indictment of an offense were also added. Here is a note. restrictions were made reasonable and justifiable only. If the law is not reasonable and not justifiable, then it can be challenges in Supreme Court and High Court. Clear after Keshwananda Bharati case. It also introduced the validity of the state move to nationalize and any business or trade and same not to be invalid on the ground of violating of the right to trade and business as well as. Next is Second Amendment Act 1952. Second Amendment Act was passed in 1952. In this amendment, the Lok Sabha representation seats by one member is increased by more than 7.5 lakh people. What does it mean? In originally, the constitution says that one MP of Lok Sabha can represent maximum 7.5 lakh people. Means if there is a place where there is 15 lakh people, then only 2 MPs will be made. Single MP cannot deal for 15 lakh people as the limitation of one MP is maximum 7.5 lakh. But in this amendment, the limitation was removed and it was said that one MP can also represent more than 7.5 lakh people. So what was done in this amendment? One MP can represent more than 7.5 lakh people under Second Constitutional Amendment 1956. So the scale of representation in Lok Sabha was readjusted starting then one member can represent either more than 7.5 lakh people. Previously it was that one MP, one member cannot represent either more than 7.5 lakh. Also Third Amendment, which was done in 1955, some changes in 7 Schedule 3 Trade and Commerce in Productive and Supply by Parliament can control. Means what was schedule? What is 7 Schedule? We have to understand also what is 7 Schedule. 7 Schedule explain 3 types of list. First is state list, second is union list, and third is concurrent list. Basically, these lists explain the power and the function of the state, center, and both. Means in state list, all the subject are mentioned where state can control or state can mention law. In union list, all the subject are mentioned where union government can make law, union government can control, and in concurrent list, all the subjects are mentioned where both state and center government can make law or state or center government can basically control these subjects also. So Third Amendment 1974, some changes in 7 Schedule were done. Means trade and commerce in production and supply will be sent to the union list. Means also Parliament can control, will be sent to the concurrent list. The trade and commerce in production and supply before 1954 was the part of a state list. Means only state can control trade and commerce in production and supply. This topic was transferred to the concurrent list. Means now Parliament also can control, central government or union government also can control over trade and commerce in production and supply. Done? Next is Fifth Amendment 1956. 1955. What was Fifth Amendment 1955? We have to completely understand what was Fifth Amendment. Here we have to also discuss Article 2 and 3. We already discussed Article 2 and 3 and what does Article 2 and 3 says? Article 2 says then union government has power, he can alter boundaries of the state. Means if there is a state, let's suppose this is the boundary of the state. A parliament declare or a parliament want to divide this state into two parts. एक X state Y. This is a state A. Now parliament, this is a let's suppose a state UP. Now Parliament can divide the border of the UP, and Parliament divided UP into UP and UK Uttarakhand. Uttarakhand was initially the part of Uttar Pradesh. Now it is separate state. This was done by Parliament only. So under amendment, oh, okay, if Parliament wants to basically separate the boundaries of the state or merge the boundaries of the state, Parliament also has to consult with state legislature. Means a bill has sent to the state also. State has to give his assent, or state has to pass the bill. But before 95, there was no specific time for state to pass the bill. State save the bill for unlimited time or for long time. In this amendment, it was mandatory that if a bill is sent to the state by the Parliament, then President will decide a specific time to pass this bill. Let's suppose Parliament want to alter the body of UP, alter the boundaries of UP. Now President send a bill to UP, then you have to pass this bill to the UP state legislature. Before 1955, UP had unlimited time that he can pass anytime. But after Fifth Amendment 1955, it was compulsory that if a bill sent by the Parliament to any state, then state has to pass this bill in a specific time which was provided by President. Mean as of now, if President send a bill to UP, then President can decide that UP has to pass this bill within 5 days, within 7 days, or within 11 days. So this state has to pass the bill within a specific date, a specific time which was provided by President. If a state is not able to pass the bill or not able to basically discuss the bill in his state legislature in a specific time, then this bill automatically declare passed by the state legislature. So this was the fifth constitutional amendment which was done in 1955. So here we have discussed second amendment 1952. Under second amendment, the representation of one Lok Sabha MP is extended to more than 7.5 lakh people. The third amendment, some changes under Schedule 7 mean trade and commerce in production and supply work is shifted to state list to central concurrent list. Fifth Amendment, it was compulsory that if a bill is sent to the state, then state has to pass in a specific time frame. Clear? So let's move to our next amendment, which is 7th Constitutional Amendment Act 1956. Most important Constitutional Amendment Act we have to discuss. Most of the changes have been done in this 7th Constitutional Amendment Act 1956. The first major change was done that the Part 7 of Indian Constitution was repealed. I already discussed that what was the Part 7. Part 7 was dealing the B state, means the 10 state of the princely states basically. The first work done in 7th Constitutional Amendment 1956 was that the Part 7 of the Constitution was removed. What was the second thing? Second thing, Parliament got power. Then Parliament can allow one governor for two or more than two states. So it was done under 7th Constitutional Amendment Act 1956. Also, Parliament can allow one high court for two or more than two states according to this amendment. The three major changes were done under 7th Constitutional Amendment Act 1956. What was the first major change? The Part 7 of Indian Constitution was repealed. The second change, one governor can work for one or more than one state, and the Parliament got power under 7th Constitutional Amendment 1956. Also, Parliament has power. Parliament can allow one high court for two or more than two states. Next is 9th Constitutional Amendment 1960. 9th Constitutional Amendment was done in 1960. Basically, the Constitution Amendment was done to give some territory which is known as Berubari. First, we have to understand the Berubari case. Let's suppose I'm making a roughly graph. Let's suppose this is the Indian map. This was the East Pakistan at that time. Bit of as Bangladesh became new country in 1971. So here, this East Pakistan was the part of Bengal, and Bengal was divided into two parts, West Bengal and East Pakistan. There was a territory known as Berubari territory. During the division, the Berubari territory was the part of Pakistan, but India captured Berubari territory during 1948. And as India captured Berubari territory, it was the part of Indian constitution. In 1958, an agreement was signed between India and Pakistan, and Berubari was given to the East Pakistan. As Berubari was given to the East Pakistan, no, the Berubari is no more the part of India. So we removed Berubari in our constitution under Ninth Amendment 1956. So in Ninth Amendment 1956, Berubari was removed through our Indian constitution, and in 1958 under Indo-Pak agreement, we gave Berubari to the Pakistan. So Ninth Amendment 1960 was done to basically remove the Berubari in India. Let's move to our next amendment, which is 10th Amendment. 10th Amendment Act was passed in 1961. In this amendment, Dadar, Nagar and Haveli incorporated in the Union of India as a union territory. In the 10th Amendment Act 1961, Dadar, Nagar and Haveli incorporated in the Union of India as a union territory. In 12th Amendment Act 1962, Goa, Daman and Diu incorporated as a Indian Union as union territory. In 10th Amendment 1961, Dadar, Nagar Haveli become the union territory of India. And in 12th Amendment Act 1962, the Goa, Daman and Diu became the union territory of India. Next, in 13th Amendment Act 1962, in 13th Amendment Act 1962, Nagaland was formed with the special status. As of now, Nagaland is also a special state under Article 371A. So he got the status of a special state under 13th Amendment Act 1962. And in which article Nagaland was added? Nagaland was added under Article 371A. So in this amendment, Nagaland got the status of a special state and he was added under Article 371A. Next, in the same year 1962, 14th Constitutional Amendment Act was done. So in this amendment, Pondicherry was incorporated into the union territory. In previously, we have discussed Dadar, Nagar Haveli, Goa, Daman and Diu became the union territory. And in 14th Amendment, Pondicherry incorporated into the Indian Union Territory. Also, Union Territory of Himachal Pradesh, before Himachal Pradesh, a Union Territory of Manipur, Tripura, Goa, Daman and Diu and Pondicherry were provided the legislature and council of ministers. State legislature or legislative assembly were provided to these union territories. So in 14th Constitutional Amendment, Pondicherry became the Union Territory of India, and also all these Union Territory got the Vidhan Sabha as well as Council of Ministers team. Next is 19th Constitutional Amendment Act 1966. In 19th Constitutional Amendment Act 1966, system of election tribunal were abolished and high courts were given the power to hear the election petitions. Before 1966, there were election tribunals. What are election tribunals? Election tribunals are some types of committees, or we can say organization. The major purpose of election tribunals to hear the disputes related to the elections only. So if there is a disputes related to election, any person can raise a complaint under election tribunals and they will try to provide the resolution and try to solve the case related to the elections only. But in 19th Amendment Act 1966, these election tribunals were removed, were abolished, and all the powers are shifted to the High Court only. Then High Court can hear the election petitions. If there is any disputes related to the elections, High Court has power, he can hear the election petitions. So as of now, there are no election tribunals. We directly have to go to High Court or subordinate court related to the election issues or disputes. 21st Amendment 1967, it was done in 1967, and in 21st Amendment 1967, Sindhi was added under 8th schedule as a 15th official language of India. What does it mean? Originally, when we discussed the schedule, in 8th schedule, there are total at present 22 languages, but originally there were 14 languages. Means when constitution was formed in 26th of November 1949, there were total 14 official languages of India. We also discussed the official languages topic in the constitutional parts. At present there are 22, means 14 or 22. What is the difference between 22 and 14? There is 8 languages which were added later. So 15th language means first language. 14th were original, now 15th language was Sindhi. And Sindhi became the official 15th language of 8th schedule under this amendment, 21st Amendment Act 1967. The 21st Amendment 1967, Sindhi language was added a language into 8th schedule of Indian Constitution. Also, there is a 22nd Amendment Act which was done in 1969. In 22nd Amendment Act 1969, Assam became the autonomous state under Article 244A. And 244 declare the tribal area of Schedule 6. We will discuss that Schedule 6 explain the tribal administration of 4 particular states. The 21st Amendment, Sindhi became the 15th language of Schedule 8 or 15th official language of Indian Constitution. And 22nd Amendment Act 1969, Assam became the autonomous state and it was added under Article 244A, and we have already discussed Article 244A in tribal and scheduled tribal areas. Next is 24th Amendment Act 1971. The President assent to Constitutional Amendment Bill was compulsory. We have recently discussed that under Article 368, Parliament can amend the Indian Constitution. Means Parliament has power. He can amend the Indian Constitution through the majority passing the bill from Lok Sabha and Rajya Sabha and after the sign of President. Before 1971, any of the house, either Lok Sabha or Rajya Sabha, can start the bill, can pass the bill and can send the bill to the President. But after 24th Amendment 1971, it was made compulsory that before introducing the Constitution Amendment Bill, President assent was required. Mean first we have to take the assent of President. If President is agree that Constitution Amendment Bill must be came to the houses, then only Constitution Amendment Bill can be introduced. So in 24th Amendment Act 1971, the President assent to Constitution Amendment Bill was made compulsory. What was 25th Amendment Act 1971? We have discussed this topic also in finance, contract and property topic. So fundamental right to property was curtailed, means some of the clauses of the fundamental right was curtailed if fundamental right to property was abolished for public welfare, then we cannot challenge this fundamental right into Supreme Court. The fundamental right to property was curtailed. As we all know, it was completely removed by the 44th Amendment and it was curtailed under 25th Amendment 1971. Next is 26th Amendment Act 1971. Privacy and privileges of former rulers of princely state were abolished. We also discussed this in finance topic. Okay. When Constitution was formed, there were a princely states in India. As after imposing the Constitution, the power of the princely state will automatically destroyed. No one will pay the tax to the princely state. The government decided that government from his fund will provided some pensions, some allowances to the princely state, and these allowances are known as privy purse. So these allowances, the privy purse was provided by the central government to the princely state as a pension or salary. But in 1971, under 26th Amendment Act, these privy purse and privileges of former rulers of princely state were abolished. So as of now, after 1971, the pensions and the privileges of princely rulers were destroyed. So this was 26th Amendment Act 1971. Next is 31st Amendment Act 1972. The Lok Sabha seats were increased 525 to 545. Originally, at present, there are 543 seats, but in 2000 till 2020, there were 545 seats. And before 1972, there were total 525 seats. So the seats were increases from 525 to 545 of Lok Sabha in 31st Amendment 1972. 35th Amendment 1974, the status of Sikkim as protectorate state was terminated and Sikkim was given the status of associated state of India. Means previously, before 1974, when Sikkim became the new state of India, it was got the title of protectorate state. Now in this amendment, the title of protectorate state was terminated and Sikkim was got the title of associated state of India. Still, it got not got the full-fledged state. Till 1974, it got the status of associated state. Later in next year, in 36th Amendment Act 1975, Sikkim was made a full-fledged state of India. Clear? So in 35th Amendment, Sikkim got the status of associated state, and in 36th Amendment, Sikkim was got a title of full-fledged state of India. And 40th Amendment Act 1976 and 42nd Amendment Act 1976. Both the amendments are done in 1976. In the 40th Amendment Act 1976, Parliament was empowered to specify from time to time the limit of the territorial water, the continental shelf, and the exclusive economical zone and maritime zone of India. Means all the maritime body can be decided by and the maritime power and borders can be directly decided by the Parliament in this amendment, 40th Amendment 1972. And for today's, our last amendment is 42nd Amendment Act 1976. So, 42nd Amendment Act 1976 was done during the time of emergency, and several major changes was done by the Indira government. As there were lots of constitutional change done in this amendment, that's why this amendment is known as the mini constitution of India. So this amendment is known as the mini constitution of India. The mini constitution, why this is known as? Because most comprehensive amendment of Indian constitution, several things were changes. What were the major changes done in 42nd Amendment? First, there were some words which were added in preamble. The word unity of the nation, unity and integrity means integrity was added, sovereignty was added, secular was added. 5 subjects from the state list shifted to the concurrent list under Schedule 7: education, forest, waste and measurement, protection of wildlife, animals and administration of justice. So this was done under 42nd Amendment. These 5 topics was the part of state list and they shifted to the concurrent list. Also, 10 fundamental duties were added under Article 51A in this constitution. Some changes was done in the Parliament. In this amendment, made president bound to the advice of the cabinet, as well as mean president is bounded to advise the cabinet. Also allow center to deploy center forces in state to deal with the conflict situation of law and orders. So before this, state center cannot deploy the state central forces into the state. After this amendment, the center got power that he can deploy the center forces into states. Also, some judicial powers like judicial review of the High Court was curtailed. Also, sub-tribunals were DPS, there were major changes done in DPSP also. So that's why this constitution amendment is known as the mini constitution. Clear? So these are important amendment we have discussed. In the next series, we will discuss the other important amendments. So let's quick revise the session we have discussed. First, a constitutional amendment in which 9 schedule was added. In second constitutional amendment, 7.5 more than 7.5 people can be represented by the 1 MP. And third amendment, some changes in the schedule. Fifth amendment, Parliament or President give a fixed time to pass a bill in state. Seventh Amendment Act, B state was removed. A governor can work for 2 or more than 2 states, and one high court can work for 2 or more than 2 states. 9th Amendment, the Berubari area was given to the Pakistan. 10th, Dadar Nagar Haveli, and 12th, Goa, Daman and Diu became the union territory. 13, 14, Pondicherry incorporated into. 19th, election tribunals were removed. 21st, Sindhi language became the new official language. In 24th Amendment, President assents required. 25th, fundamental right to property curtail, and 26th, all the allowances for privileged state was removed. 31st Amendment, 525 seats to 545 seats was increased, and 35 associated state of Sikkim, and 36 full-fledged state. In 40th Amendment, exclusive economic zone was selected by Parliament. In 42, major changes were done, and this is known as mini constitution. So I hope you understand this session.